Right. For those of you who came in late, I'm Kurt Levy, President of the Committee for Justice. This event is sponsored by the Committee for Justice as well as the Alliance on Antitrust. And we're going to talk now about the FTC and the courts. It was originally going to be the first panel, but we flipped it because the congressman on the what was going to be the second panel had a 5 p.m. vote. So with no further ado, let me introduce my colleague, Ashley Baker. She's the Director of Public Policy at the Committee for Justice.
Hi. Thank you all. Thank you all for coming. So I'll give brief introductions to our two panelists here. Without further ado, then we'll then talk about issues related to the courts in Congress. As you all know, we, in the last panel, discussed Congress and the FTC and threats they might be facing there, whether that be oversight or legislation and other issues. Here, we're going to be talking about recent cases. We're going to be talking about constitutional issues. We're going to be talking about everything within that realm of the courts and the Federal Trade Commission. So first, here we have Bilal Sayyed, who is Senior Competition Fellow at TechFreedom, and he's former Director of the Office of Policy and Planning from the Federal Trade Commission. And also we have John Masslon. He is Senior Litigation Counsel at the Washington Legal Foundation. And both have filed many amicus briefs and related to recent cases before the FTC. Both have been on this issue for a while when it comes to that intersection of the Federal Trade Commission and the courts. One within the FTC, one kind of outside doing more appellate law. So we're going to have a conversation today related to all of those things. And as we discussed in the last panel, we had Lena Khan today in front of Congress. And we have the FTC making a lot of decisions that are by some, we see them as being pretty radical, pretty outside of what the FTC usually does. In the background of this, though, we have all these court cases in which judges are looking at their records in courts. They're looking at what they're doing internally, whether that be process reforms, whether that be other things. And that's all going on in the background. And that's one big part of this picture that I think a lot of people aren't quite as attuned to is what the Federal Trade Commission is doing in courts, whether they're winning, whether they're losing, where they're filing briefs, what arguments they're making. So we're here to discuss that. I'm going to kick it off by just kind of asking a broad question of to each of you is what's your perception right now of what the Federal Trade Commission is doing in courts? What are the big cases? What are the big takeaways at this point in time?
Well, thanks for having me, Ashley. It's great to be here with you and we're all to discuss these important issues in the courts. I think that right now the FTC is being very aggressive in court. And that is both by bringing actions in its own administrative courts, by bringing actions in federal courts and defending against those cases, and also filing amicus briefs. Most of that makes the big news is the merger cases. We've all seen those. For example, the Illumina Grail, the Microsoft Blizzard, the Amgen, can go on, the Meta, on and on about the merger cases that are making the news, but it's also other types of cases that the FTC is being very aggressive on. For example, the pay-for-delay settlements in the pharmaceutical industry. The FTC has been very active in filing amicus briefs in those types of cases. They've been refusal to deal cases. They're getting involved in district courts filing amicus briefs in those cases. So I'd characterize their current posture as aggressive, and it's just been unsuccessful. The courts continue to reject the FTC's position, whether it be the Supreme Court in the Axon case where the FTC lost 9-0, the AMG case before the Supreme Court where the FTC lost 2 terms ago, but also in its own administrative tribunals. It lost the Altria Jewel case before an administrative law judge. And then just earlier this month, June 30th, the commission dismissed the case and vacated the ALJ's decision because it didn't want that ALJ's decision to remain precedent that could be cited within the agency. So they're not winning even before their own judges.
So I have a maybe slightly different take, although in the end there's some similarities. I want to say two things. Look, I think I've been at the commission. I've worked for two active chairmen, Tim Muris, 2001 to 2004, and Joe Simons, 2018 to end of basically beginning of 2021. Both of them had active agendas where they wanted to push the law in different areas. Some of what Joe Simons did, very was sort of precursors to some of the cases that we're talking about, right? I believe this is public. The agency during the Trump administration had opened investigations of the, some or most of the, large tech companies, either at the FTC or DOJ. Most of the Illumina Grail case was done during the Simons tenure, and it was voted out 4-0 by the commission after he left, even though it was under at the time Biden's acting chair, Slaughter. I was there for the AMG loss at the commission. The Axon merger case was brought by the Trump administration. Altria Jewel was brought by the Trump administration. So I use that as background to say, an aggressive agency is not, first, I don't think an aggressive agency is bad, but I think two things distinguish the con agency from, I think Simons or Muris, the two folks I worked for. I think they're pursuing cases where they have very weak facts and are sort of equating a theory of harm with a factual evidence or factual analysis of harm. And I think that is either a function of ideology or maybe what I say is very weak, what I'll call senior leadership at the bureau level and even among the commissioners, right? I don't think a guy like Rich Parker or Debbie Feinstein, woman like Debbie Feinstein, would have brought cases with such a weak evidentiary record, right? I think the Microsoft Activision case, you read the judge's opinion, you say, what's going on here, right? Who approved this? I think you can say the same thing about the Facebook Meta Within case, right? I think so. They are bringing cases that theoretically have some basis, right? We worry about the acquisition of a potential competitor or entry by acquisition rather than by de novo entry, which is the Facebook the Meta Within case. We worry about vertical transactions. The Trump administration did the vertical merger guidelines. So Microsoft Activision, perfectly reasonable theory, foreclosure, but they're bringing cases without the evidence, and I think it's part ideology. They don't like certain types of cases or certain types of mergers, or maybe any mergers, and they also just don't have the strong litigators at the commission level, at the senior management level, and I think they're not listening to staff. The second thing I think is really bad, they're using process. They're using process to, either create uncertainty or just harm firms, right? This is the new proposed HSR form. This is the stopping of early termination back there, and 2+ years ago, all on the pretext that they're not getting enough information, they don't have enough time. And that, I think, that's bad, right? People are entitled to, so-called due process, and firms are not getting it. So those are areas where I think they've really hurt themselves or differentiated themselves from past active administrations. I can talk about all these cases, but But, an aggressive agency doesn't strike me as bad if it's trying to move the law in sensible directions, if it's got facts where they say, this is bad, let's see if we can get some good law here. Debbie Majoris lost 3 merger cases in a row. Nobody called her a Marxist or ideologue. But now they're just doing this on spec, really. Let's try it and see what happens. And to me, it's just foolish. There's a lot that could have been done. There's a lot. I was part of an administration that wanted to do some things more aggressively than the previous 1 or 2 administrations. And these guys have taken that work, taken that effort, taken that attempt to, turn the ship a little bit, and I think wasted 2.5 years.
Yeah, so, I know we're here to mostly talk about cases, but, this is also related to cases. Bilal brings up a point about processes and procedures, and particularly the merger guidelines. If we could talk a minute or two about what's gone on there, and that in mid-2021, the Federal Trade Commission, they overturned their merger guidelines with no replacement. They still have not replaced those merger guidelines. When asked about, what do you comply with now, their answers were very, kind of wishy-washy in terms of, in the perspective of those who are members of the defense bar who are trying to advise their clients. And now we still have no guidelines. And we even, as of February of this year, one of our Democrat commissioners, Kellyanne Slaughter, said, Rebecca Kelly Slaughter said, look, I haven't seen actually the merger guidelines, and we still have no date on that, and hopefully they're coming soon, but doesn't that leave things very much in flux, and what's the deal with the merger guidelines right now?
Well, I'll take that on too. Again, I have a slightly different take in this respect. I think it's bad to pull guidelines, which they did, at least the FTC did, since dropping their participation in the vertical merger guidelines. I think it's bad to do that without a replacement. And the horizontal merger guidelines are, they didn't really pull those. They just said they need to be updated.
Right.
But they're bringing what I'd say is aggressive horizontal cases, or arguably horizontal cases, outside of, in some sense, outside of theories in the horizontal merger guidelines. Look, I think it might be good. Well, I have 2 thoughts on the guidelines. One is it might be good if they actually don't produce anything. But on the other hand, look, there are 2 very good economists, leading the agencies, so it is entirely possible they could have very thoughtful guidelines if ideology doesn't get in the way, right? This Amgen case is an attempt to revive an old theory of harm. It would be very bad if that made it into the guidelines. I think because it's a bad theory, but there's also no real support for it. Similarly, the Meta Within case was a potential competition case. There's a lot in the guideline. Well, there's enough in the guidelines with respect to potential competition cases. There's, I did a monograph. It's about 60 potential competition cases or more that the FTC's brought over the last 20 years. There's a lot of guidance out there. If these guys try to sneak some things in that are not tied to existing cases or maybe existing economics, it's going to be a problem. And, I don't think the heads of the economics groups, heads of BE, heads of the economic analysis group, the economists at DOJ would allow that. They're smart. But I worry that, again, that the ideology that's leading them to bring these cases that are not that they're unwinnable, they don't have the facts or the theories are bad, may make its way into the guidelines. And so, better they do nothing, I think. Although I have a 30% hope that they're actually going to potentially come out with good guidelines because they are good economists.
I think the uncertainty is just horrible for the business community because you really can't counsel your clients about whether they should go ahead with a merger or not, even though there might be some case law over the past few decades that is favorable to your client. If you don't have the merger guidelines to rely upon, and the FTC goes after you in an in-house administrative process, and they're just like, well, we don't care about what this case law says. You don't follow, our view of what the merger guidelines should be, even though we don't have any right now, then the cost is just going to get astronomical, and there's no reason to do the deal. Axon's a great example of that. The Axon deal was $12 million. Axon has spent over $25 million in legal fees to date to defend a $12 million deal. And that number is going to probably hit $40 million by the time this is all over. And why would you engage in a deal when you're going to have to pay 3 times the deal amount in attorney's fees? Most companies are not going to do it. Axon's hard-headed, so they decided to go ahead and do it. But most companies are not going to be willing to do that. So I think it's critical that we do get guidelines. Of course, they should be good guidelines, and if there are bad theories in there, those can be challenged in court. But the business community needs certainty more than anything, so they know how to act.
So speaking of Axon, one of my favorite topics, actually, we also filed an amicus brief in Axon, as did both of you, I think. And you're right, that there's a due process concern. And I would kind of categorize all of this as the Federal Trade Commission is in a due process crisis in general. There are a lot of issues here, whether, it's FTC versus DOJ and what does it mean to have meaningful due process. But there's also a lot of issues now in terms of, guidelines flipping. We have now post-Axon, though, they can bring cases in federal court that are collateral constitutional claims. We've seen a couple of cases kind of grow out of that. We have the Illumina case isn't technically part of that because they were already appealing to the Fifth Circuit, but we see something in the Ninth Circuit with Amgen, there are other cases. So, kind of what is all of that climate looking like now? What do things look like for the Federal Trade Commission moving forward? Because, in my opinion, they're flying too close to the sun. There's Lina Khan making all these declarations, and it seems that they're almost completely oblivious to the fact that there are courts who can make decisions that will eventually maybe make it to the Supreme Court if the Fifth Circuit says, there are arguments, going after Humphrey's executor, for example, in the Fifth Circuit. You have the same parallel argument in the Ninth Circuit. There could be a circuit split there. There's this whole ecosystem of things that they seem completely oblivious to. So what do I know this is a very broad question, but what do you have to say about the kind of that broader ecosystem of things that are, going on right now?
I mean, I think that what you're going to see is that the Fifth Circuit is hearing Illumina on September 12th. The panel hasn't been released yet, but based upon the panel's orders to date with the FTC's motions practice, I'm pretty confident that it's probably going to be a good panel. And I would be shocked if you don't see a decision that says either the FTC's structure is unconstitutional or that the FTC's processes violated Illumina's due process rights. And then you're not going to need a circuit split, because I guarantee you that the SG will be seeking cert on that, and the court's going to grant a case like that. And then we're going to be before the Supreme Court deciding, is Humphrey's executor still good law, or do the FTC processes violate due process? And I think that you saw the preview in Justice Thomas's Axon concurring opinion, where there are many members of the court that have serious constitutional concerns with how the FTC is acting. And I think that Lina Khan is on borrowed time, because I would say probably by, the end of the year, but early next year at the latest, you're going to get a Fifth Circuit decision that's going to stop her in her tracks.
So I again have a slightly different reaction, although, I think I think the current leadership does not have much respect for the agency as an institution, and I think they're sort of in a position where, heads they win, tails you lose, in the sense that, I think there's an interest in a so-called independent agency that is not, bipartisan or nonpartisan or multi-headed, but a single, a single head. And I think they can absorb, in the larger sense, I think they can absorb these losses as potentially, weakening the agency, removing, sort of the, I don't want to call it bipartisan structure of it and its direction over the last sort of 30 to 40 years. And so trying these cases, proceeding as they have, doesn't seem like a loss to me, right? Or that they're that concerned about the institution losing that legitimacy or even authority, because I think they're frustrated by the model, right, of 3 and 2, 5-member commission. And so if they can put more power, as they've tried, into the chairman's office, it's a win for them. If they lose and the agency, in a sense, is restructured, I think they believe it'll be structured in a way that will strengthen both the independence of the agency and also the role of the chairman, right? I mean, I think what they want is something like the CFPB. And so, if they can do it, if they can win these cases, protect their authority, concentrate it in the chairman, they win. If they lose these cases and, Congress says we need to do something different here, I think they also think they win, and get something like the CFPB. And I think both are a problem. I think the agency has, I've as sort of a quasi-academic, I've always wondered about the constitutionality of the agency and wasn't quite sure. I agreed that, it was constitutional. Wasn't quite sure that, the processes they could follow were appropriate. But in my experience, both there and as a practicing attorney, I felt they struck the right balance, more or less, over the, roughly 25 years I was practicing on one side or the other. And now, you just can't say that, right? I mean, I think they're using process to hurt people. And, there's a lot of authority there. And I think, the smarter approach is to use it wisely, not the way they've been using it. So I think they are at some risk, but I think in some sense they're not worried about it.
Quasi-academics, aren't we all? But so to kind of take things back for a minute to the 30,000-foot level, for members of our audience, I think it would be helpful if maybe each of you could explain in 30 seconds what was decided in Axon, what are the implications? I know it's hard in 30 seconds, and what's the Lumina case, what's the implications there? It'd be good to give that overview for whatever one of you wants to take each of those things.
Okay, I'll take the Axon case. So essentially what the court said in Axon, as you heard Noah say in the first panel, is that an agency's structure and processes, when you're challenging those under the Constitution, those can be brought in federal court, and the Federal Trade Commission Act does not strip district courts of jurisdiction. So the district courts have jurisdiction to hear those cases, and they don't have to be raised on petition for review to a federal court of appeals after an internal agency decision.
So on Illumina, I think the core of the question is, the basically you have an entity or an individual performing sort of an executive function, not subject to the authority of the executive branch, right? This is sort of the ALJs are protected, the commissioners are protected from termination. in performing that executive function. And, I'm skeptical as to where I'm skeptical at where the Fifth Circuit comes out on this question is, in fact, a direction the Supreme Court wants to go, because I think it will be upsetting to many, allegedly independent agencies. I hope in Illumina they just find a path to reverse the FTC on the merits and not take on the constitutional questions. I think, again, I was at the FTC twice as part of the so-called administrative state. I think a lot of people try to get it right. It's not the agency's fault that Congress leaves them with so much discretion and so much maybe ambiguity. Most of the people are trying to do the right thing. These are I think one of the downsides of the current leadership's approach is they do want to make it more of a regulator than an enforcer, and that has different sort of mindset. Most of the staff's trying to do the right thing. They want to enforce the law, and I think, at least I grew up at a time when conservatives were very focused on law enforcement, and I think we ought to celebrate that. There's a lot of I'd say activity that ought to be prevented, and pulling the rug out from the agency is I think gonna have negative effects on the enforcement side. They should have been because again, the Axon case, the AMG case was while I was there, the underlying challenges to Axon started on the Trump administration. I think it, a little bit more humility in exercising the authority that at least the agency thinks it has would serve them better, so they could just focus on their mission, which is stopping, prohibiting, maybe even deterring conduct that many people think is actually bad, and they've put themselves in a position where that good work is potentially very much at risk. Very much at risk.
And it certainly doesn't help when, acting Chairman Slaughter at the time said after the AMG case came out with a statement saying, the Supreme Court today sided on, the side of fraudsters and, scheme artists, et cetera, that sort of thing. That doesn't go unnoticed by the courts. It's, that's, I feel like, a little bit inappropriate.
I don't know, I'm a little skeptical that John Roberts listens to anything that Commissioner Slaughter or Chairman Kahn.
Okay, well,
we've been
on the record being a little bit skeptical of him listening to a lot of things, so I can't.
I don't mean that as an insult to anyone.
I
just think,
But they're not helping the case. They're not helping the case. But in general, though, let's turn the conversation a little bit to the Supreme Court. It's always hard to predict, what will make it there or not. But we do have some cases that are not related necessarily to the Federal Trade Commission, but to the SEC, to some cases that go to the heart of the funding and structure of independent agencies. We have Darkasy, which the court eventually had to grant coming out of the Fifth Circuit. We had several other cases, and I'm not asking for predictions on outcomes, because even those of us who know more than most are wrong half the time. As someone who told me years ago, who is probably someone who's most right on all these things in terms of predicting Supreme Court outcomes. But what do you see coming up the pipeline? What's next?
Well, I think, there were a few years where the agency was, looked at with favor by Congress. We wanted to give them some more money. I think that's changing now. I don't think they're going to get more money. I think the agency, I think the leadership at both agencies, but, we're talking about the FTC, I think they have a plan. They're trying to, move it forward. They want to bring more cases. They want to stop more deals. They want to expand the theories of harm. They want to limit the claims of sort of mergers lead to efficiencies. They want to move to a focus on protecting smaller firms because they believe that's protecting competition as opposed to just protecting smaller firms. I think, if the current president, if President Biden's not reelected, I think they're going to fail in their agenda. If President Biden is reelected, I think there's a good chance at the end of, what would then be an 8-year term, they will have made significant strides towards that. I mean, I think they will lose in the courts on some things, but, eventually I think firms will accommodate some of this odd behavior and or excessive behavior. I mean, look, we talk about Microsoft Activision as a loss to the commission. At least so far, we thought it was a loss. Well, Microsoft made all these commitments that in another administration would have been, incorporated into a consent order, and, it would have been, trumpeted as we got relief, right? Illumina Grail, they made commitments, and look, Illumina's lost now if you, work from the commission opinion, but Illumina made those commitments because those are the commitments you make in a vertical deal, right? Another, they should have just been accepted, right? Amgen in this, portfolio theory, enrichment theory, the theory is Amgen's going to bundle products post-acquisition, and that's going to have harm. Well, my understanding is Amgen has said, we'll give you a promise not to bundle, So firms will accommodate this stuff over time. They want to get their deals done. And, some of it, may be harmless, right? If you make a promise not to do what you weren't going to do, it's not really harm to the company, but it can have long-term harm in what you ask for, what people ask for in the future. So I think, if it's only another, 18 months of this, they probably fail. I think the court is going to, some courts, maybe every court, will push back hard on this non-compete effort. But if they have 8 years in total, they're going to make a lot of progress, and antitrust and consumer protection law, I think, will be changed, and I think it'll become more regulatory, and I think the real, the major concern is that innovation will be stifled here. That's my thought.
I mean, I think that the commission and the DOJ, if they do get a full 8 years, there are going to be some victories on the merits where they're able to block some deals here or there. But I think that what you're going to see is more structural and broader decisions, especially from the Supreme Court, that takes away a lot of power from both the FTC and other administrative agencies. I mean, we have Loper Bright that's being heard this upcoming term. We have Jarchese. There are a lot of cases up there, and I just don't think that the Supreme Court is going to bless a lot of this. We also have other types of, again, non-merger things where I think that the court will get involved with. It's, as Bilal mentioned, the non-competes. I think that the court might have to step in there in striking it down, or it just might let circuit court decision striking down that attempt stand. I also think that you're going to see another reverse payment case at the Supreme Court soon, and or another unfair competition, where, as Noah mentioned in the first panel, you have the commission that's now trying to say, anything can be unfair competition. If you have some kind of disparate impact that discriminates, that's unfair competition. I think those types of theories are going to continue to be rejected by the court. And at the end of an 8-year Biden administration, you will see a crippled agency that might have a victory here or there, but if you look at the broader picture, it's going to be a big loss for the FTC.
So, kind of going back to the broader administrative law implications that are, with Loper Bright, when the court grants these sort of cases, I mean, they don't grant a case like Loper Bright just to keep Chevron intact, obviously. You know, whether or not they will completely overturn it, or whether they explicitly do it, or they will say, you know, Congress has to explicitly say when, you know, authority is delegated, that's, you know, very much still the question. But we have the FTC issuing, for example, NPRMs about the HSR process, the merger review process, for those of you who aren't in tune to that. And like that would very much affect that sort of process. And it's, you know, it's very much outside the bounds of the statutory authority of the HSR Act, in which they said, you know, this is what you can do, this is what you can't do. It's not about who it's applied to or not, it's about, you know, it's very much a scoop sort of question. So how do you think that, you know, regardless of what way the court goes in Loper Bright, I do think they will at least narrow down Chevron. What does the agency do from there?
Well, I think the agency complains that the Supreme Court's protecting fraudsters and the like. You know, look, I think if, you know, Chevron and Auer are narrowed, the agency has a tougher time, right? They have to go to Congress and say, clarify our authority. And, you know, I can't think that there's any sensible person who believes that Congress is going to act to give the agency more authority, right? I mean, there's disagreement as to what authority the agency should have. There's just not, you know, there's just no, while there may be a you know, a coalition or broad group of senators or House members who think the agency should be doing something different than they're doing, there's not a lot of agreement on what that is, or there's not sufficient agreement. So I think the agency will be hurt. You know, the AMG decision has, you know, in a sense, upended the fraud program, right? I mean, nobody wants to defend people engaged in fraud, but the agency, you know, creatively, and this was, you know, a Republican commission back in 1980, you know, Jim Miller and Tim Muris, head of the Bureau of Consumer Protection, you know, created the fraud program and sought monetary relief, right, relying on this language that the court in AMG said, wait, this isn't clear, right? But it was a, you know, 40-year effort, and it was, you know, a reasonably effective effort, right, to do something more than just don't do it again, right? An order that says don't do it again isn't worth much. Getting money was at least worth something. That's gone now. Commission, you know, that hurts the commission. It hurts enforcement. But Congress is not rushing to fix that. So peeling back, you know, agency authority is just going to make it a weaker commission. It's going to be a commission that, I mean, look, the commission in 1969, you know, a few reports basically said, get rid of this commission or change it, you know, and if it doesn't change, get rid of it. I mean, it was a weak commission. It got more authority in the 70s. It did some restructuring, you know, in the early 70s and then early 80s. And it became a stronger commission that restrained itself in some respects. And I think where it didn't, it proceeded cautiously but sensibly. That may all go away, and you're back to an ineffective commission. I mean, the commission from, my view, 1920 to 1970 was pretty ineffective, right? It was no better than the, you know, I think, no better, no smarter than, you know, your standard news reporter who handles your consumer, you know, concerns, right? So, you know, a lot of the change has been good, even if it had skirted the boundaries. It was at least, I thought, used judiciously. Now, it's been, you know, it's been expanded. It's going to be pushed back, and it's going to be a weak agency. And again, that's a reason the current leadership, I think, sort of sees a win, right? Because it'll need to be changed. It's an ineffective agency without this authority. And I think in time, people will see that, and they may restructure it. I don't think it's going away. I think there's a lot of desire for congressionally overseen legislative agencies. Congress is not going to let that go away and give that authority all to the executive branch. So it's going to be worse. This is, wins, in a sense where I agree on the constitutional questions, are going to be Pyrrhic victories, as they say. It's going to lead to worse outcomes.
I think it's going to depend on who the commissioners are, because if you have some reasonable commissioners in there, I agree that it's going to be a weaker agency that's not going to try to push its luck. But then under the current commissioners, I think all you're going to see is them try to enforce their will through bullying. And you're seeing that post-AMG, where you're seeing these consent decrees, which are not permitted under AMG, but are going ahead anyway, because the commission is essentially saying it's going to cost you more to litigate this and to win this in court than it would for you to just pay up to us. And I think that they're going to pass rules, they're going to bring proceedings, especially under Lena Khan, and they're going to try to bully companies into settling cases or to just not merging or dropping mergers once the FTC challenges it. And I think that's where the real danger is, even if we get victories in Loper Bright and the CFSA case, where we have an agency that views its only power is through bullying instead of the administrative process as it's supposed to work.
So we'd like to get to the, happy hour intersection, but I would like to, for closeout, have 2 audience questions too. If there's anyone in the audience who has any questions for any of us.
Hi, my name is Ian. I'm from the International Center for Law and Economics. And Bilal, you make the interesting point where, this road of consistent losses leads to a scenario that this current FTC is going to potentially embrace, as Congress is going to have to re-examine some of the fundamental structure of the commission. That's leaving a lot up to chance, and while they certainly tout what victories they have and the lens in which you have to sort of peer through to see them as victories can be one that isn't readily apparent to everyone. I'm just curious if you could put more meat on the bone of what that ultimately looks like. What is the end game that they're seeking here? You mentioned CFPB, but what is the world of their future FTC in the world that they want? What does that look like?
Well, look, I think, just want to clarify something. I think they feel they win if they get a restructured agency with more power in the chair with less oversight. That's, I think, the CFPB type model. I think and maybe they get there either through losses in substantive cases or losses on, constitutional questions. But I think they also get there if they can either convince the courts after administrative litigation that, their view of what's an unfair, as an example, what's an unfair method of competition, deserves some type of deference. Or they get there, just companies say, okay, we're going to give you consents that we wouldn't have given you or wouldn't have even asked to give you, 5 years ago. So that, what do they want? I think they want an agency that looks very much like the agency in the 1950s or 1960s that protected, again, on the competition side, protected competitors because they feel either the number of firms matters, that there maybe are some non-economic goals associated with the smaller firms, and all, you know, and the base, some of the basis for that is this idea that, well, you know, we don't want to allow large firms to strangle small firms in the crib, because, you know, if those firms are allowed to grow up, they're going to be successful, right? And so we don't, you know, competition in 10 years will be affected. So, you know, I think that's sort of what they're looking at, a 1950s, 1960s type commission in terms of enforcement and protection, and a regulatory approach that was initiated in the 70s, you know, and it was initiated, you know, it was accelerated, I think, by Michael Perchuk, who you know, is a Democratic chair, but it grew out of that 1969 report by the ABA and also the Nader report, you know, a stronger commission. And so it's a combination: protect smaller firms and use rules, regulation to place restraints on you know, industries operating across the broad economy. That's what I think they want. And I think, you know, they can try through the cases, they can try it through process, but they can also do it with a you know, single-headed, you know, CFPB type agency. So that's my thought.
Okay.
It's my fear.
One more question. Yes.
Henry Hetker, retired government. The Gray Center at George Mason University School of Law has recommended that administrative courts be set up, or an administrative court, which would probably have a direct link to the FTC and other government agencies. There, you would be able to get a decision on any particular case that might make sense in the administrative, you know, area, which many of these problems that FTC faces are involved in. The other alternative is direct the courts to take action somewhere regarding a particular case. I've dealt with the FTC through a lawyer many years ago, 30 years ago, and they indicated they couldn't, there's no enforcement mechanism. They saw what was wrong, but they could recommend something, but nothing would probably be done, and they were right. But well, with the administrative court, there'll be a new outlet, a new way to get something done. Do you think this makes sense?
Well, to be honest, I'm not sure I fully understand, right? The agency has limited powers. In a sense, they can ask a district court, or, you know, to do something maybe with more teeth than they can. But I'm not sure I understand the question. Again, having practiced in this system, you know, on both sides, I think, you know, it's reasonably okay. There are many improvements that could be made in terms of process, in terms of speed. I think, in some instances, a greater respect for the fact-finding capabilities of the administrative law judge should be recognized. I mean, there is just, having been in a chairman's office and worked on opinions, you know, appeals from the administrative law judge, you know, there's just no way to do the factual finding that the administrative law judge does. And, you know, so I think some process improvements would be useful, but I don't think, I mean, again, I don't understand, notwithstanding that I teach at George Mason, I don't understand, I'm not familiar with what the Boyd and, you know, Gray folks have suggested. But you know, the creation of, to me, the creation of new entities often creates new problems. And, you know, better to make incremental, cautious changes to what exists, see how they work. You know, Bill Kovacic, who was chair and commissioner and general counsel, long history with the agency, you know, he talks about the self-improvement culture of the agency, the attempt to, you know, review what they've done and make improvements. And I saw that when I was there, sort of from the outside. I think that's the right approach, but I don't fully understand what they're suggesting.
Yeah, I mean, I have immense respect for Jen Mascott and Trent McCotter over at the Gray Center, and I'm not completely aware as well of their proposal for these administrative courts, but my general idea is that the Article III court system works well, and that's where we should be trying cases, is not in administrative courts. I think that you should be trying them in Article III courts, where most of the time you have the right to a jury and you have more due process protections than you do in an administrative agency.
So 30 seconds, 1 minute each. We have some food and happy hour and everything coming out. You all are welcome to join us, obviously. But what are each of your concluding thoughts, if you had that much time to say about the future of the agency in this area of the law?
Well, I'll sort of repeat, I think, what my theme has been. There was a need for change at the agency. Just as the economy changes, it should change. It learns, it should change. That change should be incremental and cautious and bipartisan. It should have the support of Congress. It should have, if necessary, the support of the executive branch. And the way I believe the way the current commission is structured, it's just acting, differently. It is pushing change that does not have strong foundation. It has upset, I think, its congressional overseers. It has upset, I mean, maybe it's okay that it upsets the business community, but it doesn't seem wise, right? I mean, there are a lot of good businesses out there that do good things, and in the end, you want change to be accepted as thoughtful and reasonable, and that's, I think that's how you get things done, and they're just not doing it. So, that would be my message. Understand that change to stick has got to be sort of incremental and supported, and they just don't have that approach.
I think that the current commission, and even going back a few years under the Trump administration, has been way too active in challenging mergers and enforcement proceedings generally. My view is that we need to return to the mid to late 80s. Bob Tollison, who used to be the head of the Bureau of Economics at the commission, used to say his proudest achievement was shrinking the number of cases that the agency brought by over 2/3 during his tenure, recommending that's, they were bringing 3 times as many cases as they should. I think that that's the type of agency we should have, where you're going after true mergers that hurt competition and not just hurt competitors.
Thank you. With that, thank you all for coming today. And please follow us all online. We're the Committee for Justice. I run the Alliance on Antitrust. Feel free to reach out to us anytime. We'll be around for happy hours, or at least I will be. And if it's great for y'all to come out, it's a great panel, and thank you all for coming.